I've known Chris for a number of years and very much appreciate his support in helping Covenant in its legislative requirements, fulfilling its legislative requirements under the Public Interest Disclosure Commission Act. And we do have a Covenant policy regarding whistleblowing, and it's something that we're proud of. And but it's important that we have this periodic education so we can refamiliarize ourselves with the legislation, with our own policy. And with that, I'm going to turn it over to Chris Siwaniak. And with that, Chris, I welcome you.
Excellent. Okay. Well, while this loads here, thank you very much, everyone, for taking the time to join me here today. I really appreciate the opportunity to speak with you. Evelina, can I just get a quick thumbs up just to make sure that everyone can see the presentation? We're good? Excellent. Okay. So my name is Chris Siwaniak. I'm the manager with the Office of the Public Interest Commissioner. I'm going to talk about our office today, and I'm going to talk about the Public Interest Disclosure Whistleblower Protection Act, how it works within Covenant Health, and how it protects employees. I'm also going to talk about investigations and the investigation process and what the outcome looks like. And I'm also going to talk about how our office integrates with the whistleblower processes at Covenant Health. I believe we've set aside some time at the end of the presentation to answer any questions that you might have. If I'm unable to get to your question or if we run out of time, I'm going to give some contact information. So I do hope you reach out with any questions that you have.
Again?
1 second, everyone. There we go. I do hope that you reach out with any questions you have, or if you need clarification on any processes that I talk about here today. And just a reminder to make sure that your mics are all muted. Thanks. Okay. A few weeks ago, I was contacted by a representative of a provincial corporation. And she contacted me to try to find some information and statistics on measuring employee confidence with internal whistleblower processes. So we had some discussion on that. We talked about statistics that are available and some studies and research that has been done. But what it really came down to is two things. First, where you have an organization that really promotes and endorses its whistleblower policy and procedure. That's a strong sign that employees should have confidence. And the second is organizations that want to work collaboratively with the Public Interest Commissioner's office, because we're an oversight body. So when you have an organization that comes to us and says, hey, we want to work with you, we want to promote our whistleblower policy and procedure, that's a very strong indication for employees to have confidence in their systems. So not 2 days later, after I had that conversation, I get an email from Gordon Self asking if we can collaborate on putting together an information session for employees on Covenant's with whistleblower policy. And I thought, outstanding. The timing was impeccable. So I was really the one that came up with the title of this presentation, Working in Collaboration to Support Whistleblowers. As Gordon said, I have had the opportunity to work with Covenant in the past on whistleblower matters, and it's been very positive. And they are an organization who wishes to collaborate with the Commissioner's office. So I hope the takeaway today is for you to have confidence in your internal whistleblower reporting system. What we're really trying to do and what we've been really working towards is a change in perspective on whistleblowing. When you think about whistleblowing, traditionally and historically, it's been a very adversarial process, right? Where you have an employee coming out against another employee or their employer.
Hi. How are you doing, Cecilia? I'm good.
Could I just remind everyone to mute your mics, please?
Well, it's about the same. I've been
putting the stuff on it, and in the morning it's
Can people, Cease, can you mute your
but,
mic?
by the time the middle of the day goes, it's kind of getting hurting again. But
Yeah, they take anything in the middle of the day to get you going?
yeah, I did that yesterday, and I took.
There we go. Sorry, everyone. Okay, I've muted mics for everyone for now. We'll turn them back on once it's question time. Sorry about that. Okay, so as I was saying, what we've been really working towards is trying to promote a change in that perspective on whistleblowing, where it's historically been viewed as a very adversarial process. But that's not really the way that whistleblowing is evolving. And organizations are really starting to see the benefit of effective whistleblower protection policies and procedures within their organizations. And that involves a few things. First of all, it's recognizing that employees who are whistleblowers and employers really have the same objective, and that's detecting and remedying wrongdoing. Unless it's at the highest level of an organization, an employer wants to know if something bad is happening in their organization, and they want to fix it as quickly as possible. The second thing is accepting and recognizing that no organization is immune to wrongdoing. It happens everywhere. It can even happen in our organization. So finding wrongdoing is not necessarily a bad thing. It's the consequences of not finding it or ignoring it that can be significantly worse. So where you have an organization that adopts a supportive culture around whistleblowing, and where management and employees share that common goal, that traditional adversarial relationship ceases to exist, and you're working towards the same objective. And in our view, an organization who works in that fashion is worthy of public confidence in the administration of its organization. So whistleblowing doesn't have to be that traditional adversarial process. And a lot of organizations, including Covenant Health, in my view, is really starting to embrace that philosophy and that idea. So now I'm going to talk about the Whistleblower Protection Act. The Act was really created to give employees a mechanism to be able to report wrongdoing within their organization. Prior to the Whistleblower Act, there wasn't really a dedicated process in place. An employee thought something wrong was happening. It was really up to them to try to figure out the best mechanism to use. So what the Act did is it created a mechanism, a dedicated mechanism for employees to use to safely report what they believe might be wrongdoing happening in their organization. Secondly, it creates a process to implement corrective measures when wrongdoing is found. And in doing this, the theory is that it's going to promote public confidence in the administration of organizations. But really the key feature of this is obviously the whistleblower protection, right? To be able to protect public service employees who report wrongdoing in their workplace. That's the key feature of this legislation. So the Public Interest Commissioner is mandated under the Whistleblower Protection Act to investigate allegations of wrongdoing in the public service and complaints of reprisal. The commissioner is what's called an independent officer of the legislature. For those who are unfamiliar with officers of the legislature, they're independent. So they don't report to any particular ministry or minister. They're completely independent from the public service, and the reporting obligation lies to the Legislative Assembly of Alberta. So the Act allows for employees to report wrongdoing. So what is wrongdoing? Well, the purpose of the Act was to be able to investigate the most serious and significant forms of wrongdoing. So contraventions of law, acts or omissions that cause a danger to life, health, and safety of individuals or to the environment, and gross mismanagement of things like public funds, public assets, and the delivery of the public service. and gross mismanagement of employees. So when we look at these types of wrongdoing, you can see the Act was really intended to, investigate very serious forms of wrongdoing that are harmful to the public, that are illegal, and that are injurious to the public interest as a whole. Gross mismanagement of employees is something that was recently added to the legislation in 2019. And it's something that our office has really seen an increase in, and I'll explain a bit more what that involves. Gross mismanagement of employees is described in the Act as a pattern of behavior or conduct of a systemic nature that indicates a problem in the culture of the organization relating to bullying, harassment, or intimidation. Bit of a mouthful, okay? But what it really means is it's to address significant, really systemic problems with bullying and harassment that's affecting the culture of an organization. So it's not intended to include those individual incidents of bullying, harassment, or intimidation. It's not intended to address those individual disputes between employees or between management and employees. And it's not intended to address performance management. So where an employee is unhappy with a performance management plan. The Act specifically says that before beginning an investigation, the commissioner must be satisfied that all applicable mechanisms, including human resource processes or processes under a collective agreement, have been used or considered. So when legislators included this particular provision, they did not want an officer of the legislature to end up becoming HR police. Okay, there are human resource processes within all organizations to be able to deal and address with bullying, harassment, or intimidation. It's when that conduct becomes systemic in nature and is impacting the culture of an organization, and it's infected an organization, and the organization is unable to deal with it. That's the type of wrongdoing that the Act is intended to address. So how do employees report wrongdoing? Well, the Act actually creates two separate mechanisms available to employees depending on their preference. One of the concepts behind the Act is to give organizations the ability to investigate and resolve issues themselves. And that really creates that whole public accountability piece. So the first process is an employee can report directly to the Public Interest Commissioner, or they can report to what's called the designated officer. Every public sector organization has what's called this designated officer. And this person is made responsible to receive and investigate complaints from employees under the Whistleblower Protection Act. That's their function. And the designated officer reports directly to the chief officer, who's really the head of your organization, so your president and CEO. The designated officer and the Public Interest Commissioner therefore share very similar statutory responsibilities. They provide advice about the Act to employees. They conduct investigations into disclosures of wrongdoing made by employees. And in the end, they recommend corrective measures. So for this reason, our office works very collaboratively with designated officers because we have such a very similar role and responsibility under the Act. Whenever we're engaged in some form of investigation or whistleblower matter, we'll typically always involve the designated officer. And we've worked hard to build sort of those collaborative relationships. Every public sector organization is also required to have a procedure for reporting and investigating disclosures of wrongdoing under the Whistleblower Protection Act. So Covenant Health has its own, obviously, whistleblower policy, and we've had the opportunity to review it in the past, and it's very good. It's a very good policy, and it outlines a specific process for reporting and how investigations will unfold. So this is the specific policy that employees would follow if they wanted to make their internal disclosure of wrongdoing. So what happens when you make your disclosure, either to the designated officer or the commissioner? Well, typically it's 3 steps. First of all, the disclosure is going to come in and it needs to be assessed to see whether or not it falls under the parameters of the Whistleblower Protection Act. Secondly, there needs to be a decision whether an investigation is actually required. So there's specific circumstances outlined in the Act where an investigation might not be required. And some of those circumstances are things like, well, there's a better authority that could investigate this type of issue. For example, if there's a complaint about a breach of privacy legislation, that's more appropriately investigated by the Privacy Commissioner. Another common example is what the person is reporting is not a wrongdoing under as described underneath the Act. So what they might be reporting is perhaps, for example, a policy breach or a policy violation. That's not really considered wrongdoing that the Act is intended to address. Third, once that assessment is done, either the designated officer or the commissioner will notify you of that decision, whether or not an investigation is required. So Covenant Health has its own process for how it undertakes its internal investigations. This is the commissioner's investigation process, and it's really a 5-step process. The first is defining the issue and the scope of the investigation, and this is the critical first step. So we need to be able to determine exactly what it is that's being investigated and confirm with the whistleblowing employee that that in fact is the issue that is subject of the investigation. The second step is engaging the designated officer and notifying the involved parties. So the individuals who have been accused of wrongdoing would be notified of the investigation, and we would also notify the chief officer, so the head of the organization. Next would be the meat and potatoes, the actual investigation process. So there would be records reviews, there would be interviews, there would be analysis. And typically, because investigations are into serious and significant matters, a lot of the times it takes a significant period of time. We've had investigations that are dealing with tens of thousands of records and hundreds of interviews. So they can take a fair amount of time, and every situation is unique. The fourth step is called providing an investigation summary to impacted parties for review and response. And this is really intended to meet our procedural fairness obligations. So under the Whistleblower Protection Act, investigations must be conducted in accordance with the principles of procedural fairness and natural justice. For those unfamiliar with what that means, procedural fairness is really giving the individual who's been accused of wrongdoing the opportunity to respond to the allegations and to be able to review the evidence against them. The second critical component of procedural fairness is free from bias. So investigations must be conducted impartially and free from any form of bias. So at the conclusion of our investigation, we put together what's called an investigation summary. And that details all of the evidence that has been collected as part of the investigation. And it's provided to parties who are potentially impacted by the commissioner's decision. This gives them the opportunity to review all of that evidence, correct any factual errors or perhaps errors in the interpretation of law that have been made, and provide any other information that might not have been considered. Once that step is done, then the investigation report, all of the responses and the evidence are then provided to the Public Interest Commissioner, who is an independent decision maker. She then reviews everything and makes her decision. A report is then prepared, which is given to the organizational head with recommendations for corrective measures. So that's the typical process for an investigation by our office. When are employees protected? In a nutshell, employees are protected anytime they do something underneath the Act. Anytime they do something that's written within the Act, the protection provisions apply to them. So that's typically when they seek advice from the commissioner, their designated officer, or even a supervisor about making a disclosure of wrongdoing. So if an employee were to go to someone they trust, a supervisor that they trust, because they're considering making a whistleblower disclosure, they're protected from doing so. They cannot be retaliated against by that supervisor or anyone else. When they make a disclosure of wrongdoing to the commissioner or their designated officer, when they participate in an investigation under the Act. So that section doesn't just apply to whistleblowers, it also applies to witnesses and other employees who might be asked to participate in an investigation. Fourth, when they do anything in accordance with the Act. So if they're required to do something, for example, they're required by our office to produce records or to meet with us for an interview, if they have to do anything that's outlined in the Act, they are protected against reprisal. And the last one is when they decline to participate in wrongdoing. So that section was added for the circumstance where an employee is asked to do something that's clearly wrongdoing, that's illegal, unlawful, and they refuse to do it, and they suffer an immediate consequence without having an opportunity to submit a disclosure to our office or to their designated officer because there isn't time. They would be protected against reprisal, and then there would be a response and remedy for that situation. So how are employees protected? They're protected from reprisal, and a reprisal is really any adverse employment action that an employee suffers as the result of doing something underneath the Act. And there is a significant consequence to somebody who undertakes a reprisal. It is a prosecutable offense, and the penalties are severe. It's $25,000 for a first offense and up to $100,000 for a subsequent offense. So if you have a supervisor that, for example, wants to take a reprisal against an employee and they decide that they're going to demote them and take away a job duty, those are two separate reprisals, and that's a significant consequence to that supervisor. Not to mention that more than likely the commissioner would recommend that they be removed from their position, and they could also suffer civil remedies as a result. So the whole point of those protection provisions, it's supposed to be a deterrent. It's supposed to be so significant that it just frankly doesn't make sense for a supervisor to take a retaliatory action against an employee. The second key protection provision is confidentiality. The identity of whistleblowers is not disclosed. It remains confidential. In our 10-year history, we have not identified a whistleblower. There have been some whistleblowers that have self-identified, but it has not come from our office. Only in a very rare circumstance would we disclose the identity of a whistleblower, and we envision that to be if we're required by a court of law to disclose the identity of an individual for some circumstance. And to date, that hasn't happened. The third part is the legal ability to disclose information. So what I mean here is the Act gives employees the authority to disclose and provide information that otherwise might be in contravention of privacy legislation, or might be in contravention of an employment or confidentiality agreement. The Public Interest Disclosure Whistleblower Protection Act supersedes the Freedom of Information and Protection of Privacy Act. So employees can disclose personal information, confidential information, individually identifying health information, anything that is relevant to the disclosure of wrongdoing. There's no other mechanism, internal or otherwise, that allows an employee to use that. And typically, what ends up happening is employees try to resolve what they believe to be wrongdoing using a different mechanism. Perhaps they might go outside of their organization to the media, for example. there is no whistleblower protection available for individuals who choose those avenues. And the Act is the only piece of legislation that provides those protections for individuals. The fourth piece is independent oversight. So again, the Public Interest Commissioner is an independent officer of the legislature. So although you may choose to go through your designated officer to investigate a disclosure of wrongdoing, if you're dissatisfied or you're not happy with the outcome of that investigation, or you don't think it was conducted fairly or appropriately, you can still bring the matter to the Public Interest Commissioner for another potential investigation. And the last piece is remedies if a reprisal occurs. So there is a specific mechanism in the Act that gives individuals who have suffered a reprisal the ability to obtain remedies. So the Public Interest Commissioner is the investigative authority who decides whether or not a reprisal has occurred. So the Commissioner would conduct an investigation. If the Commissioner finds a reprisal has happened, then two things occur. First, it's forwarded to the Minister of Justice for consideration of prosecution underneath the Act. That's the punitive measure. The second piece is the remedy. The matter is automatically forwarded to the Labor Relations Board, and the Labor Relations Board determines an appropriate remedy or remedies, and it can be anything from returning to a job duty to financial compensation. They really have the power and authority to rectify any situation that might have resulted from a reprisal. So a lot of information here that we've covered in a very short period of time. And some employees might be sitting on something. They think something's wrong. They're not quite sure. They don't know whether or not they should report it or not. The best advice we can give you is get advice. Okay, so if you're uncertain and you want to talk to somebody about it, you have the option to reach out to your designated officer or to our office for advice. And we can talk to you and walk you through it. And ultimately, it's your decision whether or not you want to go ahead with a complaint. Disclosures or complaints under the Act are complaint driven, meaning that neither the designated officer or the Public Interest Commissioner has the authority to initiate an investigation under the Act without an employee making a formal complaint. Okay, so that's the end of the presentation. I'm going to take questions now. So if I can't see everybody's hand here, but perhaps we could use the chat function. I think we still have about 15 minutes. Or if you want to use the reactions, and we'll try to get to that here. And just let me unmute everybody. Give me a moment. Okay, perfect. There we go. Okay, we'll start with John. You have your hand up.
Yeah, thanks. Good afternoon, Chris. Thanks very much for your presentation. Just a question, because one of my roles is as the Chief Privacy Officer for Covenant Health as well. So I work regularly with the OIPC. One thing, when you were talking about the process, I was curious about any statements you might make related to anonymity or not. So I know that there's that the person bringing forward a concern is free from reprisals, but because of the principles of justice that you elucidated, are they they're not free from anonymity in bringing forward their concern? Is that a correct statement or not?
So their identity remains anonymous. To
It
date,
does.
we have
Okay.
not. Yeah, to date, we have not disclosed the identity of a whistleblower. Again, there
Okay.
could be a circumstance. We are an administrative decision maker, so the courts do have jurisdiction over us. So there could be a situation where the court requires us to disclose the identity of a whistleblower for whatever reason. That potentially could happen. To date, it hasn't. But from our own internal policies and procedures and the requirements of the Act, we do not disclose the identity of a whistleblower.
Great. Thank you.
You're welcome. Okay, I have a question in the chat function. Could you provide some examples of situations that the Public Health Commissioner would hear from a healthcare perspective? Tammy, I'm not sure I understand your question. Perhaps you can unmute yourself and just provide a bit more clarity.
Sure. Can you hear me?
Yes.
Okay. No, just from a healthcare perspective, let's say from a frontline perspective, I'm just curious about sort of examples where someone would feel the need to go to the public health commissioner or the designated officer. Is it regarding policy, or I was just wondering if you could provide just a little bit of context to that.
Sure. Sorry, I misunderstood your question. I think you're referring to Public Interest Commissioner.
Yes.
So, yeah,
oh, yeah, sorry. Yes, that's my mistake.
No problem, no problem. Right, so really, I talked about what the Act defines as wrongdoing, right? So those are very specific categories of wrongdoing. So any contravention of an act, be it provincial or federal act or regulation, an act or mission that causes danger to life, health, and safety, gross mismanagement of either public funds or public assets. So if you're looking at it from a healthcare practitioner's perspective, it's every single case that we have is very distinct and unique. So if you have a situation where you have a business unit, for example, or your department is experiencing a gross mismanagement of employees. So you have a senior leader that is systemically harassing, bullying, intimidating staff. There have been attempts to resolve it internally that have been unsuccessful. That's potentially something that could come to our office. Or perhaps there's an employee and you're aware that they've contravened some form of regulation or a statute. That's something that could come to the commissioner's office as well. Because every situation is so unique, we have such broad scope of authority. That's why I say the best advice is to get advice, right? So if you're aware of a situation and if you're not sure whether or not it falls under the Whistleblower Protection Act, call either myself or Gordon Self, and we'll talk to you about it and see whether or not it's something that should be addressed under the Act. Does that answer your question? Gordon.
Yeah, thanks, Chris. Just wondering if you might want to comment on when PETA, your office, receives an anonymous complaint where you have no recourse to follow up with the individual, like if it might be posted online, and sort of like the position of the commissioner when it comes to fielding anonymous complaints. I know at Covenant sometimes we get messages that might be left but with no identified person we can follow up with, and so sometimes that leaves us a little bit kind of uncertain about how we can proceed. So I was just wondering if you might comment on that. And I know there's another question in the chat box I'll flag for you as well.
It's a fantastic question, and that can be the really frustrating part. Is we have received complaints where there is not enough information to go on. And the Act says if the commissioner does not have enough information to conduct a fair and impartial investigation, then she's not required to investigate it. And if we don't have the ability to follow up with a complainant and get those details, then nothing ends up happening. What we won't do is go into a fishing expedition, right? Where you have an employee that says, I think something really bad is happening in this department, and that's it. We can't go digging into an organization trying to find something wrong. There has to be some salient detail and sufficient information for us to be able to act on it. Because the confidentiality and anonymity provisions within the Act and even within your own internal policies and procedures are so strong, we always recommend, you know, if you really want to keep yourself anonymous, even from our office or the designated officer, at least get advice about doing it. Open some form of channel of communication. If you want to set up a fake Gmail address or something, at least it gives us the ability to communicate back and forth and get details if we need them. Okay, in the chat function. In the case of employee abuse, how would you determine whether it is a case for HR versus a systemic problem? Excellent. So there's a section in the Act that says all other mechanisms have to be used or considered first. So what the commissioner would consider is, are there other avenues within the organization where this issue can be resolved? The second thing that we would consider is this an individual incident? Is it a individual case of bullying one employee or a supervisor harassing one employee? If that's the case, then it's likely an issue that's not a public interest matter. It's something that can be addressed internally. What we would look for are those circumstances where there's a pattern of behavior and it's something that's reoccurring, it's affecting many employees, and the organization is not able to resolve the issue, or attempts to resolve it have been unsuccessful. Okay, seeing no other questions. Again, thank you very much, everyone, for taking the time to listen to me today. And as you sort of digest some of this information, if any other questions pop up, please reach out to our office, and I'd be happy to answer those questions for you.
Well, before you go, Chris, I just want to say thank you again. I've heard you present on a number of occasions, and I always find you very clear, articulate, and providing reassurance too about how best to reach out and contact your office. And certainly, as you emphasize, Covenant's very committed to working in alignment with the legislation and to support a healthy organization where truth telling and where if there's identified issues that we could address that and learn from that and try to move forward. So for all of our listeners today, I just want to say thank you for your participation. We will be having a similar session on June the 15th at the same time. Again, you may want to join that session as well if you join late today, or perhaps you just wanted to hear Chris again. We will be making this education session. We'll post it to our Ethics and Discernment Center website, so it'll be available for viewing after that you can share with your staff. And again, as the designated officer for Covenant, I'm always available for if people wanted to reach out, and certainly through Chris Iwaniak through the Office of the Public Interest Commissioner. So again, thank you everybody for your time today, and thank you again, Chris. Take good care, everybody.